This is part 29, and we shall be continuing our discussion regarding offenses affecting the human body. Now, in order to understand this, as I have learnt in the past, we have to start right from section 299 up to section 377 of the Indian Penal Code. And though the chapter starts right from section 299, if A has merely pushed Mr. B or given one blow to Mr. B, then this is the most simple offense with which we started, and then we had dealt with section 319, then which defines what do you mean by hurt, section 320 which defines what do you mean by grievous hurt, section 321 which defines the offense of voluntarily causing hurt, section 322 which defines the offense of voluntarily causing grievous hurt. Then we dealt with section 299 along with section 300 of the Indian Penal Code in order to know the offense of culpable homicide amounting to murder, and culpable homicide not amounting to murder. With this, we also dealt with section 301, where A intends to cause death of one person, but that has resulted into death of another person, as section 299 says, whoever causes death by doing an act, and it doesn't speak about death of a particular human being, liability of Mr. A is the same whether he kills Mr. B or whether he kills Mr. C, with which you are dealt, where we had dealt with what do you mean by transfer of malice or transmigration of motive by dealing with section 301. Section 302, as we have learned, deals with punishment for the offense of offense of murder, whereas section 304 deals with punishment for culpable homicide not amounting to murder. Section 303 deals with punishment for murder by life convict, and it says whoever being under sentence of imprisonment for life commits murder shall be punished with death. So that is, this section was challenged on the ground that it violates Article 14 of the Constitution of India. Punishment for one person may be different, but the punishment who commits the offense of murder may be any punishment from death penalty to any other punishment. But as far as the punishment to the life person who is undergoing imprisonment for life, if he commits murder, he shall be punished with death only, and that was challenged in Mitchell's case, and it was the Supreme Court has struck down section 303 of the Indian Penal Code. So now we have to read section 3 Indian Penal Code without section 303, because that has been struck down by the Supreme Court in Mithu's case. With this, we now proceed to section 304A, which defines the offense of. It says whoever causes the death of any person by doing any rash or negligent act not amounting to culpable homicide shall be punished with imprisonment of either description for term which may extend to 2 years, or with fine, or with both. And the wording clearly indicates whoever causes the death of any person by doing any rash or negligent act not amounting to culpable homicide. So man is driving his car at a tremendous speed, knocked down somebody, which results into his death. What is his liability? And this man who was driving the car had no intention to cause death. Naturally, as his case doesn't fall under any one of the ingredients as far as section 299 is concerned. And if the case doesn't fall under section 299, the question of proceeding to section 300 of the Indian Penal Code doesn't arise. Now, what is this? What is his liability? Now, he may not be liable provided his case falls under any one of the exceptions. And when we shall be working out details as far as section 80 of the Indian Penal Code is concerned, which deals with what do you mean by accident or accident as a defense, if it doesn't fall under that section, then the liability of an individual is as per section 304A of the Indian Penal Code. a man started driving car during night hours and ran over those who were sleeping on the footpath, which resulted into death of those persons. His liability is as far as section. So what is this? The first part of section 304A says, whoever causes the death of any person by doing any rash act. What do you mean by rash act? It is over hasty act. The person, for example, may not be expecting the consequences which are likely to take place, but at the same time, the nature of the act, degree of rashness is such that it constitutes liability as far as section 304A of the Indian Penal Code is concerned. When you want to cross a railway crossing when there is no person, or there is no gate, or there is nobody to take care of it, it is the duty of the driver to get down and see whether they are passing by, and that is not done by the driver, and he's without taking this care, he straightway drives, which has dashed against a rail, which has resulted into death of person. Liability of the driver is as per section 304A of the Indian Penal Code. Now, as we will proceed to discuss, for example, during course of time we will come to know the death which is caused by rash or negligent act. For example, what is when doctor wanted to give say medicine, and he has given instructions to the compounder to add say 5 cc's from bottle A. A is the name of the medicine, and 45 cc's from bottle B. B is the name of the medicine, and dilute it with the help of the water up to 100 cc's and to be given to the person. The compounder was in hurry, and he, instead of adding 5 cc's from bottle A, adds 5 cc's from bottle B and 45 cc's from bottle A. Now, as a student learning law, you have to learn many sciences also, and there you will come to know that there are some medicines. If there are some medicines which you give in moderate quantity, that will not result, that will be helpful to the person, but if you exceed it, that may prove to be harmful. Same, one dose was taken by the patient. He started showing the symptoms of poisoning. He was immediately taken to the hospital, but unfortunately he succumbed to that. Now, can it be said that the compounder had intention to cause death of the patient? The answer is in the negative. But what is the liability of the compounder? And then we say, as his case doesn't fall under the offense of culpable homicide, he is liable because there was negligence on his part. A duty of care that was required to be taken on his part was not taken by him, and hence that constitutes liability as far as section 304A of the Indian Penal Code is concerned. During course of time, there can be, as we will be dealing with general exceptions. When a doctor, for example, takes a decision to perform operation when there is no gas cylinder which is available, or performs a decision to perform operation without operation theatre, in that case, the degree of care that is required to be taken on the part of the doctor, if it is not taken by him, his liability, though his intention may not be to cause death, there is what is known as negligence on the part of the doctor, and hence the liability of the doctor will be for the offence as defined by section 304A of the Indian Penal Code. So during course of time, as I told you, when we shall be dealing with general exceptions, and if the case doesn't fall under any one of the general exceptions, because of which the act will amount to an offence and the result is the death, but if it is found out that the result was death because of the rash or the negligent act, a builder wanted to construct a building, and he has not used sufficient cement for the purpose of construction. Because of this, the building collapsed. Liability of the builder is as per section 304A of the Indian Penal Code, because what was the degree of care that was required. So this degree of care varies. as far as the doctor is concerned, as far as the builder is concerned, with which we shall be, as I told you, once we will try to understand section 80, we will come across this as far as section 304 to be read. Read in the sense we will have one few more illustrations once you understand the concept regarding general exception with which we shall be dealing during course of time. Otherwise, this is, as far as section 304A of the Indian Penal Code, which defines the, as I have told you, offence of causing death by rash or negligent act accordingly. The rashness is the over-hasty act. Negligence is the degree of care that is required to be taken on the part of an individual that depends upon the nature of the work that is required to be done on the part of an individual, and if it is not done, that constitutes liability as far as. So when we talk about, you have to correlate liability with death. The first section that we dealt is section 299. The other section with which we dealt is section 300. This is the next section, namely section 304A of the Indian Penal Code. With this now, we now proceed to the next section, namely section 304B of the Indian Penal Code, which defines the offence of dowry death. And in order to understand this offence of dowry death, let me start reading the section. And once we start reading the section, I will now, this is the technique that we will adopt for the purpose of analyzing the section, carrying out dissection of the section in order to know the ingredients of the section accordingly. But before that, let me make one thing very clear to you, that this was section 304B was an amendment to the Indian Penal Code in the year 1986. Taking into consideration the dowry deaths that were taking place within the territory of India, and when we talk about law, we say law is an instrument of social change, law is an instrument of social engineering, law must be dynamic, it cannot be static. Legislature thought, in order to curb the menace of this dowry death, let us have some deterrent effect, and hence this section was enacted, namely section 304B of the Indian Penal Code defines the offence of dowry death. Now, before we work out the ingredients of the section, let me tell you, if you read subclause 2, which deals with punishment, it says, whoever commits dowry death shall be punished with imprisonment for term which shall not be less than 7 years, but which may extend to imprisonment for life. So this is generally, whenever if you in general deal with the section where you come to know the maximum punishment that can be inflicted by the court of law, but here if you read the section you will come to know punishment shall not be less than 7 years. So the court, when a person is found guilty that he has committed the offence of dowry death as defined by section 304B of the Indian Penal Code, the punishment that should be inflicted by the court of law is never less than. This is one of the aspects as far as deterrent theory of punishment is concerned, and this is exactly the purpose has been served by making mention of the punishment shall not be less than 7 years as far as clause 2 is concerned. With this now, what are you doing? What is this offence? And hence, if you start reading, it says, where the death of a woman is caused by burns or bodily injury or occurs otherwise than under normal circumstances. So dowry death deals with death of a woman, and what is the manner in which it is manner in which the death has taken place. It may be because of any burns, or it may be because of bodily injury, or otherwise occurs otherwise than under normal circumstances. So the death has not taken place as far as the normal circumstances are concerned. It may be because of the burns, or it may be because of bodily injury accordingly. And then further part it says, it is the death of a woman, and then it says within 7 years of her marriage. So if the death has taken place within 7 years of her marriage, in other words, dowry death only relates to a death of a woman who is married, and this within what is the duration? If the death takes place within a period of 7 years of her marriage, that is the first part. So this section comes into operation in a case where death of a married woman has taken place within a period of 7 years from the date of her marriage, and what is the nature because of which that has resulted into her death, where the death of a woman is caused by any burns or bodily injury or occurs otherwise than under normal circumstances. That is the first part, within 7 years of her marriage. And then it is shown, now further ingredients, and it is shown that before her death she was subjected to cruelty or harassment by her husband or any relative of her husband. So what had happened before her death? It is a question, it is a question as far as the proof is concerned, which is required to be proved in the court of law, that before her death, and it is shown that soon before her death she was subjected to cruelty or harassment by her husband or any relative of her husband. And this is what this is in connection with, this harassment is in connection with any demand for dowry, such death, if it was in connection with demand for dowry, such death shall be called dowry death, and such husband or relative shall be deemed to have caused her death. So this is the dowry death. Such death is known as a dowry death, and such husband or relative shall be deemed to have caused her death, as far as this section 304b is concerned. But now, if you read the explanation, it said, for the purpose of this subsection, dowry shall have the same meaning as in section 2 of Dowry Prohibition Act of 1961. So what do you mean by dowry? You have to understand the meaning of the term dowry. When you read the provisions of the dowry, you read section 2 of the Dowry Prohibition Act of 1961. That is one thing. But then if it is shown, if you go back again to the ingredients, and it is shown that soon before her death she was subjected to cruelty or harassment by her husband or any relative of her husband. Now, in order to understand this cruelty by husband or relative of husband, this is the time that in order to understand section 304b of the Indian Penal Code, which was an amendment to the Indian Penal Code in the year 1986, you must know what is this cruelty by husband or relative of husband. And in order to understand this, if you read section 498A of the Indian Penal Code, which was an amendment to the Indian Penal Code in the year 1983, then it says, whoever being the husband or the relative of husband of a woman subjects any such woman to cruelty shall be punished with imprisonment for a term which may extend to 3 years and shall also be liable to fine. And the explanation says, for the purposes of this section, cruelty means. So what do you mean by cruelty now? Cruelty means any willful conduct which is of such a nature as is likely to drive the woman to commit suicide or cause grave injury or danger to life, limb or health, whether mental or physical, of the woman, or harassment of the woman where such harassment is with a view to coercing her or any person related to her to meet any unlawful demand for any property or valuable security, or is on account of failure by her or any person related to her to meet such demand. So this is the cruelty by cruelty or harassment by husband or relative of the husband as defined by section 498A. So if the death of the woman has taken place, the death of a married woman has taken place within 7 years from her date of marriage, and soon before her marriage she was subjected to cruelty or harassment as defined by section 498A of the Indian Penal Code by a husband or relative of her husband, and that is in connection with any demand for dowry, and such a death shall be called dowry death, and such husband or relative shall be deemed to have caused her death as far as section, and this is what is known as dowry death, as far as section 304B of the Indian Penal Code is concerned. Now, to understand this, as I mean, during course of time, you will also, I mean, this is a time for you to have reference to what. Now, this is a time where you, in order to understand this, you must also know the importance of section 113B of the Indian Evidence Act. In order to understand section 113B, which was an amendment to the Indian Evidence Act in the year 1986, you must, I mean, go through the chapter right from section 101 up to 114A of the Indian Evidence Act, which deals with burden of proof. When the matter goes to the court of law, how everything is required to be proved by the court of law, who has to prove, how, I mean, all this you come to know when you start reading right from section 101 up to 114A. Out of this now, section 113B says presumptions as to dowry death. There is some presumption, and what do you mean by presumption? The court will take it for granted. Court will take certain things for granted, and it says when the question is whether, when the question is whether a person has committed the dowry death of a woman, when the question is that of whether it is a dowry death or not, when the question is whether a person has committed the dowry death of a woman, and it is shown that soon before her death, such woman had been subjected by such person to cruelty or harassment for, or in connection with any demand for dowry, the court shall, in that case the court shall presume that such person has caused the dowry death. So there is a presumption. It is not required to be proved in the court of law. Court will take it for granted, a presumption as to dowry death, by having reference to section 113B of the Indian Evidence Act. So this is, I mean, the manner in which you have to understand. By you must have a cross reference to this section, correlate this section, section 113B, which says when the question is whether a person has committed the dowry death of a woman, and it is shown that soon before her death such woman had been subjected by such husband, by such person, to cruelty or harassment for, or in connection with any demand for dowry, the court shall presume that such person had caused the dowry death accordingly. And for the purposes of this section, dowry death shall have the same meaning as in section 304B of the Indian Penal Code. So that is the liability when you want to, I mean, understand the offense of dowry death, which is defined by section 304B. You start analyzing the section, and in order to understand that, it is also necessary for you to know section 498A of the Indian Penal Code, which defines the offense of cruelty or harassment by husband or relatives of the husband. And for the purpose of knowing, this is also the time for you to have reference to section 113B of the Indian Penal Code. With this now, as I mean, we have come up to section 304B of the Indian Penal Code. Section 305 of the Indian Penal Code deals with abetment of suicide of a child or insane person, and section 306 deals with abetment of suicide. But then what we will do, in order to understand this, both the sections, namely section 305 and section 306, because I have already, I mean, had drawn your attention to section 307, which deals with attempt to commit murder, punishment, and then section 308, attempt to commit culpable homicide. These are the sections where the punishment is laid down. But then to understand these sections, namely section 305 and section 306, the time for us to, I mean, first of all understand section 309 of the Indian Penal Code, which defines the offense of attempt to commit suicide. Now, once we start dealing with this section, namely section 309, which defines the offense of attempt to commit suicide, let me tell you, as this law relating to attempt to commit suicide has undergone a change. Because of what? Because of the decisions that were given by the Supreme Court. We may refer to some of the decisions which were given High Court also, but then this Indian Penal Code was enacted in the year 1860, but law relating to attempt to commit suicide has undergone a change. And because of the fact that it has undergone a change, the time for me to draw your attention to Gyan Kaur versus State of Punjab, which was decided by the Supreme Court in the year 1996, and P. Ratinam's case, which was decided by the Supreme Court in the year 1994. So this is this with which we shall be dealing as far as our next part of the lecture is concerned. And then, as we have come now up to section 3, 319, 320, 321, 322, 323 to 338 are the offences which deal with punishment. We will immediately start, as soon as we finish with section 309, we will immediately start with the next section, namely section 339 of the Indian Penal Code, which defines the offence of wrongful restraint, and section 340 of the Indian Penal Code, which defines the offence of wrongful confinement. Both the offences relate to personal liberty of an individual. And what are these offences, and rest of the details with which we will continue our discussion as far as our next part of the lecture is concerned.